Please be seated. The court is now back in session. This afternoon, we will continue with the document hearing by hearing the presentation by Ieng Sari's defense of their submission regarding the military structure, the movement of populations phases 1 and 2, and the killing site at Tul Puchirei. The floor is now given to Ieng Sari's defense to make the presentation regarding the documents. Counsel Michael Canavas, please hold. I noticed that the prosecutor is on his feet. You may proceed.
Merci, Monsieur le Président.
Thank you, Mr. President. Good morning to the bench and to all parties. Before Ieng Sari's defense presents objections to the or talks about the 54 documents, I will try to look at the number of documents on the list. 24 of those documents have already been the subject of debate and even decisions of the chamber. So in order that we do not lose time and discuss the same documents, 12 documents were discussed yesterday during the afternoon session, as well as other documents which were the subject of debate in 2012. May I take about 10 minutes to list the documents which, in my opinion, should not be discussed today. So, I am in your hands, Mr. President, if you think it is useful for me to do so that we can limit today's discussions only to the 30 documents I believe are in the footnotes of the footnotes. 24 other documents have already been the subject of discussions, and the defense should not present those documents again or should not raise objections.
President, Counsel Michael Canavas, you may respond.
Thank you, Mr. President. First of all, it is not my intention to go through each and every document, and the gentleman knows that. Our position has always been that we would do by topics. Secondly, the 54 documents that we included as part of this annex that we will be submitting to the trial chamber as part of our written submissions include documents that were noted in the footnotes. And when we look at your trial memorandum of E223/2 at paragraph 5, there seems to be an omission with respect to documents related to the military structures. And so that was the purpose of that. Now, to the extent that there may be some overlap, that's unavoidable in some instances. But we took the opportunity to look at the footnotes themselves. This presentation does not include objections to closing order documents such as IS 5.53 or D125/217, which have been included in the OCP's annex. And also we do not include witness statements requested by the prosecution in its motion of E208, E208/1, and E96/8, because we understand these will be the subject of future hearings. That said, I will agree with the prosecution that some of the topics of some of these documents are similar to the ones raised yesterday. And I'm perfectly happy to simply submit our annex, our motion with the annex and our remarks, and sit down to save time if the prosecution is worried that we will be consuming valuable court time. But what the topics that I have here are telegrams. There are letters. One needs to be, I need to clarify something with the court. A letter from Header. Then there is a letter from a pastor. There are some witness statements. There are some documents from USAID, UNICEF, WHO, the U.S. State Department, World Vision. There are documents related to international communications from the French and U.S. State Departments, again, similar to what we did yesterday. These are all from the footnotes. There are some media articles, including an article that was authored by Sun Sikun, where we don't object to that being introduced, and it sort of dovetails what he testified to, but we leave it to the court's discretion. There are 3 CPK publications and minutes of meetings. There's one video titled "What Happened to Cambodia" by Ronnie Yimsut, or Ronnie Yimsut's story, I should say. And then there is a power delegation decision by Judge Yubun Lang to Judge Lemon, allowing him to, with respect to a letter that was authored by Mr. Header. So I'm in your hands. I can either go through my presentation or simply say that with respect to all of these documents or these topics, we object based on what I've indicated yesterday, based on Rule 87.3, and based on the fact that some of the documents predate the temporal jurisdiction, and unless they meet certain criteria, that it is for background or for context, anything that precedes the temporal jurisdiction of this tribunal should not be admitted. With respect to the Header letter, it is worth pointing out that this is a letter from Header to the OCIJ while he was working for the OCIJ, explaining certain matters, and it bears underscoring that Header's summaries of Becker's interview with Ms. Ingterit was not admitted because it was found to be unreliable. In other words, somehow he was transcribing or typing her notes, and that was found unreliable, and that's in E185.2. Very briefly, again, to save time, since time seems to be of the essence, with respect to these documents from USAID, UNICEF, and what have you, as I've indicated yesterday, we think that trial chambers should give little or no weight, should not take the content of these documents at face value. It is virtually impossible to test the validity of what is being reported. These documents and reports contain information and conclusions that are based not on direct observations. Basically, these are my submissions. And I see the prosecution seems to be in a particularly combative mode this afternoon, so I'll allow him to make his observations.
President, thank you. The co-prosecutor, you may proceed.
Monsieur le Président,
Mr. President, I had made a motion before this chamber, and Councillor Carnavas was given the floor to respond to that motion, and it appears that regarding all the motions, I think he should respond to my specific application, and depending on the decision of the chamber, I would be able to say which documents are duplicates or duplicate others, and then he can make his objections. I think he is mixing things up. I still do not know whether the chamber would like me to list documents that have already been the subject of hearings before. Thank you, Mr. President.
President, that is correct. If you object to certain documents and that it is not necessary for Insurance Defense Council to present those objections in order to not to waste the time, you should list those documents so that the chamber and all parties will get to understand clearly on this issue. And if you just make a brief summary, then the chamber will not have the basis to make decision. You have to state that clearly. For example, out of those 24 documents that you're seeing are repetitious if to be presented by the Defense Council, so that the Council will have the opportunity to make their remark or observation. So that we can then decide whether the defense shall make their objection in whole or in part. And if you make a brief response or remark like this, the chamber will not have any grounds to make any ruling.
merci. En fait, j'avais demandé l'autorisation de...
Thank you, Mr. President. Indeed, that was the main thrust of my application. I will move very quickly and in an orderly manner regarding the table given by the defense. The first document was on the table sent by email this morning is D108/28/108. It already has an E3 number, and this is E31750, and it was presented before. This is a witness, Ms. Verne, who was presented during the hearing of the 8th of August 2012 by Judge Lavergne. E1/131.1 at about 11:50. There were no objections raised at the time regarding that document. The second document, which poses problems, is number 3 on the list, given by the Insari Defense Team. It's D108/31. I repeat, D108/31.28. As a matter of fact, in this case, it is another version of a document that had already been the subject of a hearing. The same document, but was presented at another time, D08/7.3. An exhibit number was given. The exhibit number was read too fast, Mr. President, so we couldn't retain it. That document was presented last year. And then, as Young Series Defense has pointed out, there are a number of witness statements on the list. The first witness statement, which was the subject of a separate hearing, is D125/97. It is a witness statement by TCW 231. Then we have 4 documents that were discussed during yesterday's hearing before this chamber. These documents begin with D199/26.2. The first D199/26.2.209 was on the list presented yesterday in the Annex 2A. The number is E223/2/1.2, and the number given to that document on the list was number 7. It is not necessary to revisit it because we talked about it yesterday. The second document is D199/26.2.219. It's in the same situation. It's on the annex we talked about yesterday. The number in the annex is number 8. Then we have D199/26.2.228. Still in the same situation. We discussed it in yesterday's hearing in the afternoon. That document has a number. It's number 9 on the Annex 2A. It has an exhibit number 228/8. Then we have D199/26.1.2.6. It was discussed yesterday, and it is number 11 on the list, the same Annex 2A. Then we have two other witness statements. They were interviewed by co-investigating judges, D32/26, D232/26, and it is witness TCW 389. Then we have D233/8, and that is witness TCW 796. So these two witnesses will be the subject of a separate hearing. Then we have a document D269/9.1.16. It was number 19 on the list, produced by Counsel for Evidentiary. The E3 number is E3/1765, but it also has another exhibit number, E3/781, and D366/7.1.157. As a matter of fact, this document is on our list of documents of July 2011. That is document E109/4.1, and it is in Annex 2, and this is number 16 on that annex. It was the subject of a hearing in January 2012. And let me point out that the documents listed on the defense list, that is D269/9.1.16, is absolutely identical with D366/7.1.157. So the E3 numbers were given to this document following its decision 185 of April 2012. On number 20 on the inquiry list, we have number D299.1.15R. As a matter of fact, that document already has an E3 number, and it is E3/3091R. E3/130R, that document is on our list of July 2011, D109/4.1 in Annex 16, and the number is 150 on that annex. The decision was therefore taken regarding that document, and an E3 number was given to it following adversarial discussions in March 2012 and following a decision by the Chamber E185.1. On number 23 of the young service list, we have document D304/1.3. That document is on our list of July 2011, D109/4.1, Annex 12, number 555. This is also a statement by an individual, but he didn't give a statement before the investigating judges, and it should be the subject of separate hearings for all documents on Annex 12 and Annex 13 of our July 2011 documents. There are 8 documents that were discussed yesterday, and I will simply read out the exhibit numbers and the references and the number in which they appear on Annexes A, B we discussed yesterday. The first document is D313/1.2.65. It is on the table which we discussed yesterday, E223/2/1.2, and it is number 13 on that document. Then we have document D365/1.1.10. That document was presented yesterday as well, and it is in the same annex, Annex A, E223/2/1.2, and it is number 18 on that document. Document D365/1.15. That document is in the annex, the same Annex A, and it is number 19. It was discussed yesterday. We have document D365/1.7, and it is number 21 on the Annex A, which we discussed yesterday. Document D365/1/123. That document is also on the annex we discussed yesterday, and it is number 23, Annex A, and the reference is E223/1/1.2. Then we have D365/1.1.28. It is number 26 on the same Annex A. Then you have D365/1/1.3 is number 17 on the annex that was presented yesterday and discussed. And then we have D365/1.1.34, and it is number 27 on the same annex, Annex A. And then we have a few other documents which have already been the subject of hearings. The first is a statement by a witness, D369/6. That one has not been the subject of a hearing, but it has to be the subject of a separate hearing. It is also on Annex 12, and the number is 189 on our list of documents on the E109/4.1. I note that in the list that was given us today, that the Ingsari defense noted a document E108/810. It is no longer on the list of documents discussed this afternoon, and we have only 3 documents left. The first is a document with the reference IS13.30, and the reference number is E3/800. It is a document that has already been the subject of a hearing in mid-January 2012, and it is on our annex of e-documents, and it's E109/4.1, and it is Annex 3, and the reference number on that document is 40. Your decision, E196 in April 2012, has already determined that it is an admissible document, so it should not be the subject of a debate any longer. The situation is similar for IS 13.1. It has another reference number, and it is D248/6.1.5. And an E3 number was given to it, and it is E3/822. This document is on our list of documents dating back to July 2011, and it's E109/4.1, and it is on Annex 3, and the number is 40. Under reference D48. The two documents, IS 13.31 and D48, are identical in Khmer, although in English there is a difference in that one is longer than the other by a page. It's worth pointing this out. And the last document, which should be presented in a separate hearing, is a statement by a witness, TCW 325. And the reference is IS 19.71. The reference is D366/7.1.587. This document is part of Annex 12, and the number is 488 on our list of e-documents, and it's E190/4.1. But as I pointed out, as is the case with other witness statements, it should be the subject of a separate hearing. I have come to the end of my list. It was somewhat fastidious, but it was, I believe, useful.
The President, thank you. I note the intention of the lead co-lawyer for the civil parties. Do you have any observation you want to make? If not, we wish to hand over to the defense team to discuss the request for withdrawing certain documents for the reason that they have overlaps. President, do you have any observation to make, lead co-lawyers? Because just now we granted you the floor, but you did not react. And
I would have made the point if I had been authorized, Mr. President, but at this stage I want to make a preliminary remark and have a clarification before our colleague from the defense makes his objections, because it seems to me that he takes it for granted that he is entitled to submit objections in writing. But yesterday the Chamber explained how the teams of Nonche and Kyosampan could make objections in the future because their clients were not there. But I want to know if the Chamber does in fact authorize subsequent later written objections to be submitted by the defense of Yang Sadi, because I think that that could otherwise modify the oral discussion that we're having here today. I'd be most grateful for clarification on that. Thank you very much.
the President, thank you. Now I hand over to the defense teams. Mr. Michael Canavas, you proceed.
Thank you, Mr. President. It's my understanding that the prosecution had the list of documents that the 54 documents as of yesterday, no complaints were raised at the time. And while, as I indicated earlier, there may be some overlap, we took it upon ourselves to go through the paragraphs dealing with military structures and try to be as diligent as we possibly could in identifying what we thought were documents that had not been discussed or not been admitted. So to the extent that we have listed here for our presentation, which was, I should say, although it's not an excuse, put together in a rather rushed manner, to the extent that we have presented overlapping documents, we apologize. But be that as it may, we firmly submit that our presentation is based on topics. And of course, in the future, if the prosecution, especially this particular prosecutor, is so concerned about time, then it would be useful if in advance they see that we are in error and they have sufficient time to point the error to us. We would gladly look at those submissions and so as not to waste anybody's time. As for the civil party, yesterday, I believe she was here. I thought I saw her here. I thought I saw her hear what I had to say concerning our written submissions. And I believe in the past we have submitted written submissions, and I don't recall ever hearing her ever raise an objection then. And now she's seeking clarification. However, if she had heard my submissions yesterday, she would have also heard that I too was seeking clarification of how is it that you wish us to proceed, because it has been our particular habit that we submit, in the past we have submitted written objections to documents in addition to any oral presentations. If the trial chamber does not wish to have written submissions, then we need some clear guidance. But we think it is useful, especially since we're dealing with so many documents. We're changing from D's to E's. There's so much that can be lost by all parties concerned, that having something in writing, especially if they are dealing with topics, might be useful. And I might add that this is the habit that it is employed by other tribunals dealing with war crimes. Our submissions have already been made. I just made them prior to the prosecutor standing up for the second occasion. We've indicated our objections to the type of documents that we think should not come in. If a witness is expected to come in and he hasn't come in, then those documents should not be used or introduced at this point in time. If and when they come, they can be shown the documents. The prosecution or any party can move for the admission of those documents or statements. As respect to all other types of documents, as I've indicated, letters, documents generated by governments or NGOs, we are already on record as to why they should not be admitted. And again, to the extent that our list overlaps documents that have already been discussed, albeit under different names, we take this opportunity to apologize for wasting everyone's time. Thank you.
The President. The Chamber has heard various issues raised by parties to the proceedings concerning the documents sought to be put before the Chamber, as well as the submissions by party and a response by various parties to the oral application by the parties. And to ensure the smooth proceedings, the Chamber will adjourn now for deliberation until 20 to 3. Or rather, until 3, and the Chamber will resume at 3. The court is now adjourned.